almost discussed section 190. In section 190, we discussed that the court magistrate can take cognizance on receiving a complaint or on receiving police report. And the third category is any person on the information of any person. Any person means other than a person or a person who is no more concerned with the criminal case. Okay. But after section 190, there are certain exceptions. And today we have to discuss those exceptions. Section 195, 197, or section 195 to 199. What you have to study section 190 and section 195 to 199. Other sections are no as such relevant or important. Exception in the context. Why these exceptions are there? Are the exception to general rule. What is the general rule? The general rule is this, that anyone can set the machinery of law in motion, of criminal procedure, or as far as criminal procedure is concerned, the object of these exceptions is to prevent improper or reckless prosecutions by private person for the offences in connection with the administration of public justice. Okay. To make it more simple, in section 199, and not to speak of section 199, we know it that suppose if a criminal case is committed, when we were discussing the FIR, so we have come to know that any person can give the information of that offense. Okay. In the like manner, the magistrate can take cognizance on the information of any person. Now, this any person widens the scope. There are certain situations where certain check are given, or there are certain restrictions in the form of exceptions which are given in section 195, 197, 197, etc., etc. Okay. Let us come to section 195. It is about section 195, which talks about the prosecution for contempt of. It is in two parts. One is related to the public servant, and another is related to the court. Prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence. This is the heading of section 195. What does 195 say? It is very simple. It says that no court shall, mind it, shall, no court shall take cognizance related to Contempts of lawful authority of public servant. Contempts of lawful authority of public servant. Okay, you must have heard about certain controversies. For example, if you may remind that there was a controversy, there was the GNU case. In GNU case, a police case was investigated against Kanhaiya and one Khalid Umar. Hmm. If you remind that there was some controversy that the Delhi government, there was a long delay in that case, and the controversy was that Delhi government was not giving sanction with regard to those cases, and that's why the court was unable to take the cognizance of those cases. Okay. It is not exact that, but it is to make it simplified, to simplify it so that we could understand the concept of the cognizance. For example, recently there was a controversy relating to you heard so many cases, so many FIR were filed in particularly in Bollywood when the Me Too issue was in news. There was a certain time every day there was one FIR against some dignitary, some celebrity. Do you remember?
Yes, sir.
Yes. And the media, such FIR was in such a manner that we as a public started to think that now this celebrity or this particular person is going to be hanged because the FIR is lodged against. But what is the point? The point is, do you hear about all those FIR and the cases these days? Do you hear?
No, sir.
Why? This is the reason of the cognizance. This is because of cognizance. Okay, one may file lodge an FIR, but whether the cognizance will be taken by the court or not, it depends on the situations. There are many situations. For example, one is related to the time limit, limitation period, and because of these so many exceptions. FIR may be filed, may be lodged, but it is not necessary that that case will or shall sustain in future. Okay. Another controversy you may remind that there was a controversy in Jammu and Kashmir. One Colonel Gogoi tied up a person in the bonnet of a car, and there were certain human rights organization lodged an FIR against Colonel Gogoi. And after some time, there was the controversy. What was the controversy? The central government was not ready to provide the sanction. Sanction means there are the certain cases where without the sanction of the concerned government, a court cannot take cognizance. Previous sanction is essential. And after some time, that became a political issue. Some political parties were of the view that the why the sanction is not being given by the central government, and other political parties were making it the issue. Why are all these things? All these things are because the reason is with regard to the cognizance, there are certain exceptions. Do you get it? Okay. Let us come to back to section 195. So section 195 is about, it is in two part. One part is related to the public authority, where the court cannot take cognizance in the contempt of lawful authority of public servant. And what are those contempts? It is given in clause, subclause A. 1. For example, not for example, it is given. Of any offence punishable under section 172 to 188 of IPC. If any offence is committed under section 172 to 188, you may go through the IPC and look into the section 172 to 188, what they are. They are related to, uh, mostly related to the contents of lawful authority. For example, section 172 is about if the summon is issued to somebody and that person is absconding or is avoiding the service of summons, absconding to avoid the service of summons. If the summon is sent by the court and the person to whom that summon was sent, he is avoiding the service. It is an offense under IPC, under section 172 of IPC. In the like manner, section 186, where it is about the obstructing a public servant in discharge of public functions. If a private person, if some person obstruct a public officer, public servant, in discharging of his duties or of his functions, public functions, it becomes an offense under IPC of section 186. So such type of offenses are given from section 172 to 188. So this is one category. Okay. Second, first the offense, these offense, and the second the abatement of such offense or attempt to commit such offense. The category of the offenses which are given from section 172 to 188 and abatement of those offense and the attempt. You know what is the attempt of an offense? And also any criminal conspiracy to commit such offenses. Such offenses means the offenses which are given from section 172 to 188. If these offenses are committed and if there is an attempt to commit such offense, if there is an abatement to commit such offense, if there is a criminal conspiracy to commit such offenses, in such situation, such condition, the court shall not take cognizance of that case except on the complaint in writing of that public servant concerned, or of some other public servant who is administratively subordinate. Meaning thereby, at this moment we can only say only and only that public servant, if that public servant files a complaint and that too in writing, only and only the cognizance of that offense can be taken. So what does it mean? It means that as in the general rule which is given in section 190, where we read what we read that the court can take cognizance on the information of any person. That is not applicable in such cases. Here is the case, only and only that public servant, that public officer has to file a complaint and that too in writing. If it is not so, the court will not take cognizance of those cases. Right? Second category, which is related to the code, which talks about of any offense punishable under any of the following section. It is clause B, following section of the Indian Penal Code, namely section 193 to 196, 199, 200, and 205 to 211. This is the category of the offenses. In 228, when such offense is alleged to have been committed or in relation to any proceeding in the court. Now keep this thing in mind. If any offense is committed under these sections are related to, for example, section 193, which is related to the punishment for false evidence. Where the evidence is given? Evidence obviously is given in the court. If the false evidence is given in the court, that is an offense under section 193 of IPC. Okay. For example, section 209, where dishonestly making a false claim in the court, or if somebody makes a false claim in the court. Section 211, where the false charge of offense made with intent to injure, which popularly we say that झूठा केस लगा दिया किसी के ऊपर. The person who is filing the case, he knows it well that it is a false case. If knowingly somebody files a false case, that is an offense under section 211 of IPC. So now you must have an idea about the category of these offenses. Section 193 to 199, section 209 to 11. Okay, all these are offenses which are mostly related to the code. And any offense, this is one category. The second category, in any offense described in section 463 of IPC, section 463 of IPC is related to cheating. Okay, or punishable under section 471, section 475 and 476, all these offenses are related to cheating. Okay, if any of such offense falling under this section is committed in respect of document produced or given in evidence in any proceeding before the court. The first category you have seen where the section 193, 199, etc. And the second category which is related to the offenses of the cheating. Cheating is the general offense. It can be done by any person, but here we are talking about if any cheating is being done in relation to the proceeding before the court. You have to differentiate it. Okay. And any third category, any criminal conspiracy to commit, attempt, or abatement, as it was earlier, of any of the above mentioned offences. In these categories, a court cannot take cognizance of a case unless or except on the complaint in writing of the court. Court itself has to give the complaint, and that is in writing, or by such any other officer which is deputed by the court for this particular function. So what do you see? We see in these cases, though these are the cases which are the offences under IPC, under the specific section of the IPC, but in a specific and a particular circumstance situation, a court cannot take the cognizance of these cases unless it is reported by the court itself, or where this offense or before which court the offense, or in which court the offense was committed. Now here is the deviation from the general rule. What is the general rule? If an offense is committed, anybody can report, any person can initiate the criminal proceeding. But here is the deviation from that general rule. These are the specific categories of the offenses and the offenses which are committed before or against a specific category. Specific category means the one category is the public servant and the other category is the court. If such thing happen, in that case, the conditions have been laid down under section 195, and before taking, or the court cannot take the cognizance of such offences unless those conditions which are given in section 195 are followed. Is that clear? Any question up to here?
Sir, what you just said something right now. We last में sir, the 195 is followed. Sir, I did not get that. अभी sir, what you just said last thing.
190 section 195 no?
हाँ, आपने सर अभी जो लास्ट में एक सेंटेंस बोला था ना, बस वो मेरे को समझ में आया.
I am talking that it is very simple. Section 190 lays down the procedure of the cognizance. We have come to know what is the cognizance of a criminal case. And in section 190, it provides that the cognizance may be taken by the court on the police report, on the complaint. Okay. Complaint means a complaint filed by the complainant, and on the information of any person, any other person. For example, if an offense is committed, for example, a theft is committed in your neighbor, okay, and somehow the neighbor, the house of the neighbor is locked, or he is out of station. Nobody is of that family in the house. You are entitled. you can lodge an FIR. It is very simple. Okay, you can lodge an FIR. In the same manner, when the question of cognizance comes, the court can take cognizance on the information of any person in the like manner as the FIR is being filed by an unknown person. But there are certain categories where this general rule is not applied. There are certain exceptions. One exception is section. There are so many other exceptions. We are coming to those exceptions. The one is section 195, and this 195 is divided. Can be divided into categories. One category is the offences committed against the public servant. Public servant means the police officer or any other public servant. And another category is the offense committed before or in the court, during the proceeding of the court or before the court. So for these categories, there are certain rules have been laid down under section 195. And for taking the cognizance, those rules have to be followed by the court. If those rules have not are not being followed, that means the cognizance shall not be taken by the court. Okay. For example, to make it more simple, there are, because there is as such no time limit for filing or lodging an FIR. But all these things are seen by or looked into by the court. At the stage of the cognizance, what happens? Many cases, the FIR have been lodged in many cases, and that has become the material of for the media. Very highlighted becomes, and after some time, we don't hear anything about those cases. And try to see this thing in your practical life. After some time, you will hear nothing about those infamous or famous or highly hyped cases. What is the reason? Because they somehow are not sustained before the court. And that part is not highlighted by the media. Okay. So section 195 simply say that these are the categories where the cognizance can only be taken only and only on the report of public servant or on the court itself, and that report must be in writing. Okay. Now come to section 196. This section is about prosecution for offences against the state and for criminal conspiracy to commit such offences. Now this is a separate category. What is that category? Offences against the state. What are the offences against the state? Offences against the state. Suppose any offence punishable under chapter 6 or under section 153A of IPC, 295A. What are they? What is 295A? To outrage the religious feeling. So such offences are offences against the state or any other, it may be any other offence which is against the state or any criminal conspiracy relating to these offences against the state or any abatement. Abatement which is described in section 108A. This is the one category. At this point of time, we should only keep in our mind that the offenses against the state. Okay. In such cases, a court shall not take cognizance of any criminal case unless there is a sanction of the concerned government. The concerned government may be the central government, state government, or in some cases, district magistrate. District magistrate or DC is also the government. If there is a sanction of the government, if there is no sanction of the government, the court cannot initiate the proceeding. And that was the case of General Gogoi. Do you get it? And that was the case of Kanhaiya and Khalid Umar, etc., etc. Because in that case, the concerned government was the Delhi government. The Delhi government has to sanction. And without that sanction, this is the let down law, which is very clear in the section 196, that the court cannot take cognizance of such cases. Right? No court shall take cognizance, and all the offenses you will realize that this is the particular category of the offenses. For example, section 153B, which is related to the national integration. If there are such offenses, or in the conspiracy of such offenses, abatement of such offenses, in such offenses, the prior sanction of the concerned government is essential. If there is no sanction of the government, the court shall not take cognizance of that case. It is very clearly given in section 196. Okay? Any question?
Sir,
Yes.
sir, regarding the any offenses that is any offense that may be committed by the public servant, in that case, the court in order to take that cognizance of the offense, it requires the sanction of the state, right?
Any offense committed by?
But the public servant, sir.
Yes. If any offense is committed by the public servant in the course of his duty or in the performance of his duty, in that case the sanction is essential. In the performance of his duty. For example, the case of Colonel Gogoi was that he was performing his duty. What was the duty? They were given the duty to maintain the law and order of that particular area. And there was stone pelting there. And they were unable to come out. That's why they tied down a person on the bonnet. But what was this? All was within the performance of their duties. Okay?
Okay.
On the other hand, you must have gone through that news. In Madhya Pradesh DGP, Director General of Police, beaten up her wife before the servants and some staff. And it became viral. Even the television channels showed that scene. The Director General of Police was beating his wife. Okay, it is
Yes,
a
sir.
recent case. It is. I think it is a week ago.
Yes, sir.
Yes, and he was suspended. Hmm. He was suspended for the sake of departmental inquiry. That is a different thing. It is not required at this point of time. Okay, but this offense. What is this? This is an offense. It may be an offense under section 498A or and so many other section of the IPC. But this is not within the performance of his duty. He was not performing his official duty. So if FIR, if the investigation is done in this case and the cognizance is taken by the court in this case, there it is the sanction is no required at all, no more required. There is no need of sanction in this case. But if the that DGP is performing his official duty by virtue of DGP, in that case, sanction is always essential. You get this thing?
Yes, sir.
Okay.
So I have a doubt.
Yes.
So in I was looking through the IPC, and you also mentioned section 196, which is issuing evidence known to be false, right? And you also mentioned it was related to public prosecutors, right, which actually are represented are counsels for the state. But usually, as far as what I've read, usually like there's the prosecutors actually have a bias towards who they're representing, and this is further corroborated by like all the incentives these state high courts give to prosecutors, because they can the more convictions the prosecutors get, they get rewards or something on those lines. So my question is, are there any provisions like penal provisions which also kind of remand like prosecutors who intentionally withheld crucial evidence which would change the course of the trial?
As such, there is no specific law for this, but it is given in the IPC itself. It is given in IPC. A complaint may be filed if such thing happens. Complaint may be filed against that prosecution officer. It is an offense. Of course, it is an offense under IPC.
So they can't withhold evidence in the court because it won't favor their because it won't favor.
Obviously, and all these offenses are covered under the heading of cheating. There are different forms of cheating. It is a kind of cheating. Case may be lodged against him. But as per your question, there is no specific law exclusively for prosecution officers. It is uniformly applied for all the officers. If there is any dereliction on the part of any officer, there are, of course, there are various provisions, and not in the special law, in the IPC itself. IPC itself. Okay.
Okay, so
And beside this, every department has the provision of departmental inquiry if there is any dereliction on the part of any officer. So every department has the provision of the departmental inquiry and departmental action may be taken against that officer. That is the different thing. But as per your question, as you are asking, is there any law to punish him? Yes, there are the laws. Not only one law, there are so many laws. But it is the second part of your question may be, does it happen or is it possible? The answer for that question is it is near to impossible and it does not happen. It rarely happens. There are number of cases where the police killed the person in an encounter. Police fired the person, murdered the person, killed the person, and police showed it all these things and create the situation that there was an encounter between the police, among the police and the accused and the criminals, and because of that encounter, those people were killed. Okay, it happens so many times. But sometimes the case are deducted and are reported and are investigated, and there are sometimes the police persons are convicted for the false encounter. Okay, but the ratio is very less, but sometimes it happens. In the same way, if there is a default on the part of the public prosecutor, if somebody pursues it, and the persuasion in our system is very difficult, it is very long, it is very embarrassing, harassing, time taking. And what is the general tendency? We avoid all those things. But if somebody pursues that, of course, even the public prosecutor can come under that category. Because what happens in the cases of encounter, in specific cases, sometimes the certain cases are pursued by the affected persons or by some organizations. Ultimately, although it takes time, but ultimately encounter is proved to be false or fake encounter. Okay, so that is the different thing. The answer is the law is there, but what happens and what does not happen, that is the different thing. Okay, anything else? Okay, the next section is section 197, which talks about the prosecution of judges and public servant. Earlier section was also against the offense against the public servant or offense in the court. But don't be confused, this section is different. Prosecution of judges and the public servant. What does this section provide? When any person who is or was judge or magistrate or a public servant, okay, not removable from his office save by or with the sanction of the government, is accused of any offense alleged to have been committed by him while acting or purporting to act in discharge of the official duty, the no court shall take cognizance of offence except without the previous sanction of the concerned government. And somebody of you has already asked this question. Okay, the answer lies in this section. If any judge, any magistrate, any public servant who is performing his official duties or who had performed his official duties, suppose for example a public servant is now retired, it is about his past services in both cases relating to any offense during the course of his performance, during the course of his the duties, official duties performance, not for private affairs. And if any case is brought against that public servant, judge or magistrate, that the court shall not take cognizance unless there is a sanction, prior sanction of the central government or the state government or the concerned state government. Okay. For example, in the cases of the armed forces cases, who is the appropriate government in the cases of armed forces government? The central government. The previous sanction of the central government is essential. If any offense, if any case is to be brought against the personnel of the armed forces, and it depends on under whom, under which government that servant is working. Either he is state government servant or the central government servant. But the suppose if the Article 356 is imposed in certain state, during that period it is considered that all the officers, servants, public servants are under the central government. In that case, though he may be the state of government servant, but in that case the central government sanction is required. Okay, it is very simple. If any offense is committed during the course of his duties by any judge, public servant, magistrate, that without sanction of the government, the court cannot take cognizance against that officer, judge, or magistrate. It is all about section 197. I think it is enough for today. We shall be